session. Let all who have cause to plead draw near, give attention. You will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is Trezzeri v. Eckert Realty Corp. number 2024-1755. Whenever you're ready.
Mr. Chief Justice, and may it please the court, my name is Stephen Morse. I'm here today with my co-counsel Samantha Vassiana. We represent the petitioner, Ellen Trezzeri. It is an honor to be in front of you today to explain why the 4th DCA opinion in this matter should be reversed. The 4th DCA's finding that Trezzeri failed to provide evidence of negligent maintenance is in direct conflict with Florida law, and it puts the 4th DCA out on an island by itself. Florida law is established that a building code violation is evidence of negligence. I want to start today this analysis by going through and breaking down the 4th DCA's opinion in this matter. The 4th DCA...
Can we talk for a second about what the role of a building code violation? No one in this case is alleging that the property owner was informed of a business code, of a building code violation, right?
That's what they're saying.
Okay, so the violation, if it exists, is sort of this abstraction. It's a thing that may be true, but has never been communicated to the property owner, and the city, having passed upon it and approved the building design, has not declared that there is a violation, right?
If we're taking their word at face value, correct.
Okay. Well, I mean, is there anything in the record that causes us to believe that that a violation was ever communicated to Eckert Realty or to anyone else at this property?
There's not.
Okay. So in order for the building code violation to be evidence of negligence, shouldn't we have as sort of just a postulate that it be communicated first? I mean, what else is a business owner to do in order to behave reasonably under circumstances like this if the business owner isn't even aware of the violation because the city has passed upon it and said there is no violation?
So they still have the duty to maintain. They also had the duty to bring in Fabre defendants. They had the duty to bring in a cross-claim. None of those things were done, so at the end of the day, it's going to fall on their shoulders.
What about the situation that is the case here, where the plaintiff, your client, who was injured, actually had superior knowledge to that of the owner about the slope? She walked up and down those steps or whatever it was, that ramp, hundreds of times because she worked there. I mean, seriously, I mean, how can we overlook that?
So I take issue with the statement that she had superior knowledge because the trial court record shows that she worked there for approximately 4 years. Trial court record also shows that Eckert owned and worked at the building since at least 1988. And further, if we provide any evidence of negligence, then it's a comparative negligence issue. The superior knowledge, Lynch v. Brown, the first DCA case, 1986, says it's a superior knowledge is a comparative negligence issue because it brings in comparative fault.
So if I buy a house, and let's say I buy it from a family who had a family member who was severely disabled, and they had built a ramp in front of the house in the front door to get in and out. Lived there for years. And I buy the house, and I decide to keep the ramp for whatever reason, and somebody, say the mailman or the FedEx guy, whatever, goes up the ramp and falls. How could, I guess I'm liable under your view.
You're liable because you have a duty to maintain. You could have had people come check it out. It sounds, I mean, in this case, he's stating on the record that he did and it wasn't brought up to him. But this isn't an issue where it is slightly more sloped. We are talking more than double what is allowed by the Florida Building Code and ADA. So the 4th DCA likes to call it a ramp. Ramps need to have handrails. If it has a handrail, it can be sloped over, I think, 8.333. But if it doesn't have a handrail, it's called a walkway, and it can't exceed 5. Here, we have anywhere from 10 to 12, depending on where you're on at the ramp. So there is implied constructive knowledge there. The Supreme Court case, a 2001 case, Owens versus Publix Supermarkets, they, in Justice Lewis's concurrence, quote, a 1983 case, 3rd DCA case, Mabry versus Carnival Cruise Lines, Inc., in saying constructive or actual knowledge is irrelevant in cases where it's not transitory foreign substances if there is ample amount of negligent maintenance found. The reason they are making that distinction is because if it isn't a transitory substance and it's there, there's going to be implied constructive knowledge there.
So if I'm trying to grasp, because see, the whole idea of premises liability is that the owner or manager of the property, whoever's in charge, either knew of the dangerous condition or had been there long enough or whatever that would give him constructive knowledge of the dangerous condition. So I guess are you saying that because there's a code violation of the slope or the pitch of the slope or whatever was wrong with it, that renders it like, in a sense, negligence per se?
No, not negligence per se, evidence of negligence. The majority of the courts in Florida say it's evidence of negligence. There are 3 that I want to point out that are in direct conflict with the 4th DCA's opinion in this matter.
So that evidence of negligence, you're saying, gets you via directed verdict?
In every case I've seen in Florida that's gone to the appellate level. And there's 3 cases I want to point out that take it the next level. They don't say that a building code violation is
How
evidence.
do you distinguish between evidence of negligence and, so the Florida Supreme Court case that talks about this prima facie evidence of negligence distinguishes between negligence and actionable negligence. What do you see as the distinction between calling something negligence and actionable negligence?
So the Florida courts are divided right now on that. The actionable negligence, I think it just depends on what district you're in right now. I don't think it's fully settled.
Okay, well, how about this? So actionable negligence in the case cites to the CJS, which just has the elements of negligence. And so why would it not be that when the court in that case was referring to negligence and actionable negligence we know is the elements of a negligence claim, not all of which are satisfied by a building code violation. So why wouldn't saying that building code violation is prima facie evidence of negligence, why wouldn't that be essentially building code violation is prima facie evidence of a dangerous condition? So why is that not like a better expression of what's actually happening?
I think it is a better expression. As you said, it is in the Supreme Court a concurring opinion on Owens versus Publix, but it's also in the 1st DCA case, Dudowitz. It's a 2021 case. I think that's in direct conflict with the case we have here, and I think it's a very important case to point out because the defense in that case was actual or constructive notice. The court still, their ruling was we have a building code violation that is prima facie evidence of negligence. Another case.
But hold on, but just to be clear and just to kind of round out that question though, I mean, I think the point is that it's one of the elements of negligence is to show that there was a breach in the standard of care, right? The role of the building code is that's one type of evidence of what the standard of care is. If your ramp falls below the building code, the relevance of that is that is just one piece of evidence that shows that you did not live up to the standard of care with the ramp. There's other elements. Obviously, for it to become actionable negligence, someone actually has to be injured, and there's, you know, other things like that. But isn't that really, so it's not so much even whether there's a violation or what's communicated to you or whatever, on the element of, did you live up to your duty to present a, you know, reasonably safe ramp? Obviously, there's evidence on the other side that it was reasonably safe because no one had been injured, and we don't really know from the facts in this case how big of a deal in the real world this percentage variation was, but it is to the extent that you had to come forward with some evidence of a deviation from the standard of care. That's basically the role that this building code is playing, is that it's giving you, you know, one way of measuring the standard of care, and they fell below it, and we know that kind of as a matter of law, that's a recognized form of evidence of deviation from that. It's not conclusive, but it is indicative of it.
Right, and that's why it should go to a jury. And
Okay, so if it does fall within the duty of care, so you have dangerous condition duty of care, that could also include maintain or warn. But then, do you agree with the Florida cases that say premise liability has those 4 core negligence, but then it adds on control and actual or constructive notice? So essentially 6.
Yeah, so what I would say is the cases that deal with, in addition to a building code violation, and talk about the next step, whether there's actual constructive notice, they tend to be the first DCA cases. We've got, which I said, the Lynch case from 1986, but every time they talk about, you know, was it open and obvious? Who knew more? They're always talking about a duty to warn. They're not talking about negligent maintenance. So sometimes in these opinions, they are starting to group it all together where it should be divided out.
So, I mean, should it be divided out, though? Because, so, okay, I guess I have 2 questions. First question is, if we agree that building code violation falls into the duty of care element, then why is the 4th DCA wrong for then separately addressing actual or constructive notice? Because I think we've established building code violation, duty of care, but still, even if you've established that, you need actual or constructive notice. And that's where the 4th DCA is saying that the prima facie evidence of negligence in the context of building code violation doesn't satisfy that additional premise liability specific requirement of actual or constructive notice.
So, and they're on an island in saying that, other than what I just pointed out, some of the first DCA case law that's actually talking about duty to warn. So what the ruling was in this case was, and I'm just going to read it for you guys.
But hold on, can you just focus on her question, though? Because, look, they built the ramp, okay? The thing had been there for 30 years before the accident happened. We're not talking about looking at a brown piece of banana and trying to figure out if it was there for an hour or for 30 seconds. So the question I think that you need to help us figure out is, what is it that he has to have had notice of? So obviously, we're well beyond the point of, he's on constructive notice of sort of the slope of the ramp and everything, right?
Right.
He's on constructive notice of what the building code requires and what that standard of care would be.
Right.
Right? And so why, I guess the question would be, why isn't that enough to get to the jury on whether there was both evidence of the breach, i.e. the deviation from the standard of care, and notice of what the condition of the property was? I mean, nobody could argue that the defendant here didn't know what the slope was and what the ramp is and whatever. It's really just a question of, like, should I be able to get a pass on that because 30 years before the accident, someone, quote unquote, didn't testify or anything, that this was, quote unquote, inspected, and that nobody complained about it since then. I mean, that seems like that's what it comes down to.
Yeah, so, you know, they found 2 things, as you know. One, that Strazzeri failed to present evidence of actual or constructive negligence, and 2, notice, and 2, that Strazzeri failed to present evidence of negligent maintenance. They cite, once again, the public's Supreme Court case. I think it's important to point out that they cite that under the finding, because when you take them together, what that tells us is They are saying because Trezzeri did not prove negligent maintenance, she then has to prove actual or constructive notice. And then we see that in the actual holding. The holding's language is absent evidence.
Just to be clear, though, are you disputing? It seems that you can win even if there is a constructive notice requirement. You've argued that. You agree with that,
yes.
Right? Okay. And so how was that met here?
The constructive notice, the one argument is that it's implied. The majority of courts don't even touch on it because it's not a transitory foreign substance. The closest case that touches on it is the Dudowitz case from the first DCA. They go through the analysis, and then regarding actual constructive notice, they just, one sentence, say it is inferred by the length of the existence of time.
Well,
and then they move on from it.
Because they created it. Because if it's your ramp, if you built it, I mean, you know what I'm saying? This
right.
isn't the sort of the core application of the constructive notice thing is when you're not the one that, you know, something is where it's not supposed to be, but you didn't put it there.
Right.
And so then, you know, but I mean, here it's like they built the ramp. I don't even know if really the maintenance is really the issue, because those cases seem like they talk more about, okay, was your deck, did you leave a lot of leaves on it, or did you let it get slippery or something like that? I mean, this is just basically baked into the very design of the thing. You know, it's not a matter of, like, he could have maintained it. He could have swept it and cleaned it and made sure the railings were, you know, tight and whatever. But if the thing is sloped too much, I mean, that's the question. Is it unreasonably dangerous or not? And it seems like it's a weak case on that, but I mean, for you, I mean, you did have some evidence of it.
And we just need some evidence to get it to the jury. The jury correctly heard all this, and they found my client 30% at fault. I want to get back to...
I had a sort of following up on all these questions. I want to go back to the question of jurisdiction in the first place, and where the conflict is.
Mm-hmm.
So the fourth DCA acknowledges what all the other DCAs acknowledge, is that the building code... a building code violation creates a dangerous condition by an owner. So, okay, but then they go one step further in your case and conclude that because there was basically no knowledge, like there wasn't proof that the employer had, excuse me, not the employer, but the owner had sufficient knowledge, or there was no proof at all really of knowledge, that was a basis for a directed verdict. If not after the plaintiff's case, certainly at the end of the defendant's case. So with that, where's the conflict? What's the DCA decision that says that it's, I guess, threading the needle? It's not negligence per se, which it sounds like is what you're arguing, but it's you know, it's more than prima facie evidence of negligence to get you through those other elements as well.
Okay, so two parts to that answer. The first being what I was about to get into. The exact ruling from the fourth DCA is important here. What they say, word for word, is absent evidence of Eckert's actual or constructive knowledge of a dangerous condition or negligent maintenance, Eckert's motion for directed verdict should have been granted. So it's key here that it says or negligent maintenance, not and negligent maintenance. They are not requiring an addition here. They are saying the reason you need actual or constructive notice here is because we are not finding negligent maintenance. So it's an or, not an and. And to answer your question about the conflict, I've already talked about the Dudowitz case. The two other I want to talk about, because I have 2 minutes.
Yeah, but which of those cases, and what I want to know is which, because we're talking about express and direct conflict. So like looking at the four corners of this opinion and comparing it to decisions of other DCAs, which other DCA has said more than just the building code violation is prima facie evidence of negligence, but that it substitutes for and no longer requires the plaintiff to show any notice at all?
So the
basically, a latent building code violation is sufficient to get through jury.
I see what you're asking. The closest case is the third DCA Mabry case, which the public's case, Justice Lewis quotes in his concurrence. That is once again saying actual or constructive notice is irrelevant when it's not a transitory or foreign substance, when there's ample evidence of negligent maintenance. Now, to answer your question about what is most directly in conflict, the Sutley case needs to be pointed out. It came out after this decision. It is the most factually analogous case we have. In there, he tripped and fell due to an abrupt change in elevation. They found it was prima facie evidence of negligence. And then another third DCA case, a 1989 case, Holland versus Baguette Inc., also says prima facie evidence of negligence. The reason I want to point that one out is that is one of the cases that is cited by the Florida Supreme Court Standard Jury Instructions Committee. It's 4019. It's titled Violation of Statute, Ordinance, or Regulation is Evidence of Negligence. So we already have it in our jury instructions. I think it's pretty clear there.
Well, except then how is it that it's not, we know it can't be negligence per se, because this court has said that in the past. So this is just, it's prima facie evidence of negligence, which means that there can be other evidence that shows that it's not negligence.
Right.
But what you're saying is that it was enough for you just to show that there was a building code violation and that you get to the jury on that. And my question then is, well, what's the jury supposed to decide then? What's the fact question if you're right on that?
So the jury takes that into consideration, as well as what was brought up earlier of how long she worked there, how many times she worked it. That is all relevant stuff for the jury to take into account.
But that has nothing to do with what the owner knew or didn't know and what they were supposed to do about this ramp. So they've had multiple inspections. No one mentions anything about the degrees. Is the owner himself supposed to go out there once in a while and measure the angles?
They have a non-delegable duty. In this case, they could have brought in a Fabry defendant. They could have brought in a cross-claim.
But that's not statutory duties of care. That is like in litigation. I'm asking, in a negligence case like this, what is the jury issue that you think is still present? And there has to be one, because it can't be negligence per se. What is the jury question? What would the jury otherwise decide if not a question of notice? And if you don't put on any evidence that the owner knew at all about this violation, and they put on evidence that shows that he absolutely didn't know, why is that not a directed verdict thing? And just getting back to and then this all comes back to the jurisdictional question, isn't that exactly what the DCA said in this instance? Is that, okay, you didn't show evidence of notice, so you lose on directed verdict.
They are saying you didn't show evidence of negligent maintenance. That's why you have to prove actual or constructive notice. They are saying or, not and. And we'll just go in through it. The first DCA says evidence of negligence. The second DCA says evidence of negligence. Third DCA says prima facie.
The fourth DCA doesn't disagree with that. They recite it verbatim, that concept.
The main thing that they're on the island out is about is there was evidence of a building code violation. Every other DCA says that gets you to a jury. This is the only case I've seen that's reached the appellate level that says it does not.
Okay, you can have 15 seconds to finish up and then get 2 minutes for rebuttal.
So I broke down that it's an or, not an and. So there is proof that there is building code violation, so the analysis of actual or constructive knowledge should not even come into play. It's well-established Florida law that a building code violation has at least evidence of negligence, with 3 of the DCAs seeing prima facie evidence of negligence. As such, we pray this honorable court will reverse the 4th DCA's decision in this matter.
Thank you.
Good afternoon, Chief Justice and members of the court. My name is Ryan Shea. I represent Mr. Eckert or Eckert Realty, and it is an honor and privilege to be before you today, and I thank you for your time. The petitioner is asking the Florida Supreme Court to fundamentally rewrite premises liability by arguing that a building code automatically mandates a jury trial. The petitioner is attempting to transform a piece of evidence into strict liability. Florida law has consistently rejected this attempt, and a property owner is not an insurer of an invitee's.
Do you concede that a building code violation, if it is communicated to a property owner, is enough to sort of open the door to a jury trial?
I think in line with the Owens decision, the court has opined that you can avoid showing constructive knowledge or actual knowledge if you can show that there's ample evidence of negligent maintenance. Here I think that if the building code was, if there was a code violation that was conveyed to the building owner, that would satisfy the actual notice requirement that would get them to the jury.
What about, are there any uncommunicated building code violations? Another way, sort of another way of posing this question is, is it not true that we assume some degree of constructive knowledge if the building code is in place on the part of owners, even if they haven't been officially notified by a municipality of the building code violation?
Most certainly, Your Honor.
Okay, so then what's the difference? Which are the building code violations that, notwithstanding the fact that they haven't been sort of notified, sort of brought to the attention of the owner, are sufficient under your account of the law?
Well, to kind of piggyback off of what Justice Tannenbaum was asking, is it comes down to a conflict that the opposing side is presenting. It's not really a conflict. In fact, the Fourth DCA opinion is in line with all of the other DCA opinions. And to answer your question pointedly, there needs to be some aspect that is open and obvious. And it's not, I'm not totally piggybacking on the concept of the open and obvious, but in all of the other opinions, the first, second, third, and fifth DCA cases that were cited by the appellant here, there's an element or an aspect, a factual position, where a jury could infer that the property owner must have known. For example, in Dudowicz, there was a 3 1/8 inch lift on a board. They said that.
But you wouldn't know. The condition of the lip is open and obvious, but whether that's a building code violation is not open and obvious. Just like with this, the slope of the ramp is open and obvious. Whether it's a building code violation might not be open and obvious. Can we just, because the Fourth DCA I thought was a little loosey-goosey with this sort of multiple inspection thing. So let's just, I want to make sure that we're all on the same page with the record. It was inspected, it seems like your client testified that the ramp, when it was redone in 1999, was inspected. The ramp itself was inspected as part of that, right? And obviously, that's, hearsay and whatever, but let's get beyond that. This accident happened almost 30 years after that, right? We don't know anything about whether the building code changed in between. As far as the multiple quote-unquote inspections, what I read was that he was repaving the parking lot every 5 years or whatever. People were inspecting that work, and that in connection with that, quote-unquote, no one said anything to him about the ramp, okay? So given that, is it fair to say that it, quote-unquote, passed multiple inspections, the ramp?
Yes, Your Honor.
Okay, and why is that?
The reason for that is because Mr. Eckert testified in the trial that the subject area where the plaintiff allegedly fell was inspected and passed multiple times.
He didn't say that, though. He said that there were inspections in connection with repaving the parking lot, but he never said that they inspected. First, I mean, putting aside all the problems of how, hearsay and who inspected what and what it means and whatever. And again, you could imagine the city coming in and testifying, okay, yeah, it wasn't technically up to code, but we consider this safe anyway, right? In which case then, the jury would have to, it would become an even weaker case on the merits. I don't think anybody is suggesting that this is a strong case on the merits. I think obviously the challenge here is the posture with the directed verdict and everything. But I didn't see in the record, even putting aside the hearsay thing, that the city in the 30 years in between 1999 and 2018 or whatever, whenever the accident happened, that they actually truly inspected the ramp itself as opposed to just stuff that was going on around the ramp. I mean, if I restripe the parking lot, what does that have to do with the ramp?
I think you're correct, Your Honor. However, I do recall reading the transcript, and if I may, I recall Mr. Eckert testifying that the subject area was also inspected.
He said no one ever said anything. No one ever, I think his words were, no one ever complained about the ramp.
Right. And
meaning the inspectors.
Correct. And most notably, we're talking about a variation of a difference of 2.67%. It's not really visible to the naked eye, and really the Fourth DCA.
Right, but that's relevant. That's relative. Is the deviation from the building code visible? But the slope is visible, just like the lip is visible. I don't think anybody's thinking that whether it's a building code violation is open and obvious. I mean, that's where you do get into the black letter law of the constructive knowledge of what the building code requires. Mm-hmm. And coupled with factually, when you build the ramp, you're constructively, at a minimum, aware of sort of what the slope of the ramp is, right?
Yes, correct.
I mean, so that's the evidence. That's the evidence of knowledge, is that this, your client had a ramp there for 30 years that objectively in the real world.
1999 to 2018. Right?
Okay.
Yeah.
Sorry, he owned the property for 30 years and the ramp for 20 years. But the point is, he objectively knew what the state of this property was, right?
Yes, and Your Honor, that goes to the question of superior knowledge. And here, there was no evidence to suggest that he had superior knowledge at all.
Can you talk a little bit about where you think superior knowledge fits in? We've talked about that this building code violation could fall into duty of care, and we've expressed subsets of that duty of care as failure to warn or failure to maintain, depending on the circumstances. It seems to me that those are not two separate, but kind of expressions of when a duty to care might be breached. In other words, sometimes it's presented in the case laws. You have the duty to maintain and the duty to warn, but it seems to be more accurate to say you have the duty to exercise reasonable care. In the case of open and obvious, that's both those kind of elements of a duty to care are satisfied because it's open and obvious. So where does superior knowledge fit in your view, within the elements of a premise liability claim?
Well, in line with Dudowicz, Parker, and Deering, superior knowledge can be inferred by a jury and is a question for the jury if it is open and obvious, and there's some reasonable basis for the property owner to be aware of the condition, or the jury could infer that he should have otherwise known through some sort of defect that was visually apparent. Here, the factual distinction that we have in this case is we're talking about, according to the expert's testimony, a 2.67% variation in the grade of the slope that without a proper measuring tool or a piece of equipment to determine that, looking at it visually from the naked eye, it's just not apparent. And so the question turns on it's not Ms. Trezzeri's requirement or to prove that she had superior knowledge. It's in line with the Eckert opinion from the 4th DCA. It's the property owner who has to have that superior knowledge. Here we have testimony where almost 2 million people traverse the walkway over the many years. Dr. Eckert testified that his patients as an OBGYN, pregnant women, use that ramp many times. Pregnant women are known to have balancing issues. He even testified that some women who are carrying largely may have difficulty seeing their feet directly below them as a result of the baby bump, and they've never fallen. And so there's really no indicia here at all, or any facts or evidence that were supplied by the appellant at the trial level to suggest that there was any superior knowledge on the part of Mr. Eckert. And again, that was a requirement that was repronounced in the 4th DCA opinion.
That seems like that, the superior knowledge thing, though, I mean, I only saw that in the duty to warn context. In every single case, whether it analytically makes sense or not, the court always talks about there was a duty to warn claim, and then they will sometimes talk about the superior knowledge thing. And then when they're talking about the maintenance claim, I never see the superior knowledge thing there, because obviously you could imagine, I mean, the slope could have been like this and it would be open and obvious, and nobody, you couldn't get out of being liable for that just because, well, I mean, they knew they were going down a ski slope, tough luck if you fell on that, right? I mean, that has to be the law.
Yes, correct, Your Honor.
Okay, so I mean, I think the 4th DCA, I'm not saying that they necessarily got this wrong, but that one little aspect of their opinion seems to have been something where they may have gone astray from sort of the way this black letter stuff is handled.
Mm-hmm. Hey, counsel, on that point, I mean, what evidence did the plaintiff present that showed that your client knew or should have known about this 2-degree variation that violated the building code?
Well, in line with the 4th DCA opinion, there was none. There was no evidence to show constructive knowledge. There was testimony, and as it relates to some of the other precedent and legal holdings that were cited in appellant's brief, all of the other cases involve issues where a property owner could walk around exercising diligent care and see that there's visibly something wrong that could be a danger. Here, the opposite is true, and so the opposite inference has to be true as well. If a property owner is exercising diligent care and they're restriping the relevant area and they're going through all of these inspections.
Relevant area, restriping the parking lot. How far is the parking lot from this ramp?
Well, again, and I apologize, but my understanding of the trial transcript was that Dr. Eckert testified that in addition to restriping the pavement, just as Your Honor, Justice Munoz pointed out, he also testified that the subject area was also redressed.
repaved?
Not repaved, but I guess resurfaced. His words were surfaced.
No, he didn't it was resurfaced when they redid it in 1999. He didn't testify that they were resurfacing the ramp each time they were doing that.
I don't think that.
Tell me where in the transcript he said that.
I would have to find it.
I think what he testified was that basically the ramp kind of ended basically at sort of the parking lot. That there was sort of a seamless transition from the bottom end of the ramp into the parking lot that they were resurfacing and restriping. But I mean, just as a layman, and part of the problem with this case is you didn't have any testimony from the actual city people and whatever. But as a layman, I mean, if I'm restriping the parking lot, that just doesn't seem like there would be any reason to be like getting out there measuring the ramp without, someone putting on evidence as to why that would have happened.
Yes, certainly. Your Honor, with respect to your prior question, you had inquired as to where in the transcript, and I would direct the court's attention to, I believe it's page 140. Line number 6 or 7. So it starts at the top of the paragraph. Mr. Eckert states, and I apologize, I'm in the middle of the testimony, there's cracks, and to be safe, you maintain the property properly. Every 5 or 6 years, I got to resurface. So a month before this happened, I had the complete parking lot resurfaced and restriped, including the area in question. And so with that, I think here we have, not only does Mr. Eckert have no superior knowledge because it's not open and obvious or something that is visually apparent to him who is always in the building and works in the building, but he also says that I'm constantly maintaining this thing. I have 2 million people traversing it every day or, over the course of time. I have pregnant women that are traversing it. Nobody is slipping and falling. And the best evidence that they have is expert testimony that says there is a hyper-technical defect in the slope of 2.67% variation that's just not visible without any piece of equipment to measure that. And so
you're asking us to assume as lay people that that's a hyper-technical violation, right? I mean, the witness didn't testify to that.
No, that's correct, Justice. However, his
testimony... Did the plaintiff present any evidence that highlighted the significance of that deviation or highlight how the owner should have known? I think there's a little bit of confusion over negligent maintenance. So I'm having a hard time understanding how one maintains a non-compliant ramp. That sounds like that's not maintenance. That's like tearing it down and rebuilding it, which is a different question. Mm-hmm. So this your client was maintaining a ramp that he did not know, at least according to the evidence, did not know was in violation of the building code.
Right.
So what what evidence? It seems like the plaintiff typically bears the burden of proof. Was there at least the burden of production? Was there any evidence that the plaintiff presented about how this deviation should have been known to your particular client, this particular owner?
No, and as the 4th DCA correctly pointed out, there was no evidence relative to constructive or actual knowledge, or what would have gotten them past that hurdle is in line with the Owens case. If they would have shown that there was ample evidence of negligent maintenance, they would have been able to avoid that hurdle. But there was no evidence at all to support that there was any ample negligence.
Well, go ahead. No, look, you agree that the question on the breach question, the question is this unreasonably dangerous, right? And you agree that we decide what's unreasonably dangerous just by, it's a factual question of sort of what is the standard of conduct. You could bring in 50 contractors and they could all testify about what they do, and then you could kind of reach a conclusion from that about what's reasonably dangerous, or flip side, what's reasonably safe, right? The law says that one way that we can sort of skip all that and get to evidence, not conclusive, it's not, per se, but one type of evidence is that you violated the building code, right? That the building code itself sets the standard of care, okay? So the other side had evidence that your client presented to the world an unreasonably dangerous ramp, right? I mean, that's just one piece of evidence. Obviously, there was lots of evidence on the other side that it wasn't dangerous, but that's one piece of evidence. So that's one thing. Now we get to the notice part, okay? So you kind of have to accept the fact that there's evidence that it's unreasonably dangerous. You accept that, right?
Yes.
Okay. So now it's how do we prove constructive notice? There's a mountain of law that says you have constructive notice of the law of these building codes, right? So how do you overcome that?
Well, just as Justice Sasso pointed out, there are other elements that need to be proven, and you can.
I know, but just focus on this one element. We're focusing on, is there a dispute of fact on the element of constructive notice? We know that the law says we impute constructive notice that you know the code, right? Mm-hmm. It seems to me that what we have here is basically a de facto defense that you're saying that because I passed the inspection, that trumps the constructive notice that I otherwise would have had of the code. No. Like, if there had never been an inspection, would you agree that this would have to go to a jury?
Not necessarily, because again, it would still be the plaintiff's burden to show that there was some factual evidence to support constructive notice.
What do you mean? But the whole point of constructive notice is that you're on constructive notice of what the building code requires.
You're in constructive notice of what the standard of care is. But
which in this case, one data point for standard of care is the building code.
Correct.
Okay.
But it's not evidence of a breach of that standard or notice of a breach of that standard.
I mean, you're not disputing that the thing violated the code, right?
No.
Okay, so you did breach the standard of care. If that particular measure of the standard of care, I'm not saying that it's up to the jury to decide whether it was unreasonably safe or not, but you did breach that.
Yes.
Okay.
But that doesn't make any sense. I mean, this court has said that it's not negligence per se. So it can't be that just showing a violation of the building code gets you not just to the jury, but essentially to a verdict, because there's nothing else to show. If you're in violation of the building code and you're on constructive notice that it was a violation of the building code because you're supposed to know all the code, what else is there left to prove to a jury? I think that's the point of this court saying it's not negligence per se, it's prima facie evidence of negligence, suggesting that there's more that the plaintiff has to show. They just don't have to show that it was unreasonably dangerous. They have to show why is it that your client is liable for the damages, which means that they have to prove more than just the building code violation. Is that not?
I agree with you, Justice Tannenbaum, and with regards.
And that's what the Fourth DCA was saying, essentially.
Yes.
Which I don't see any conflict between that and what other DCAs have said.
Yeah, can I ask you, what do you think this case was decided on?
What do I believe the case was decided on?
What element, like what rule of law, what was this case decided on?
It's the lack of knowledge, I think, is the primary issue.
Okay. And do you think that it's so lack of knowledge, not superior knowledge, just pure lack of knowledge on behalf of the?
I think I misspoke. It's the lack of actual or constructive notice. Okay. That is the primary issue. And the Fourth DCA points out that there was a way to get around that hurdle. And it was if they showed, in line with the Owens case law and the Mabry case, if there was ample evidence of negligent maintenance, which there was also none.
And do you think there's a conflict on that actual or constructive notice issue?
No. No. All of the other cases that are cited that the appellant alleges is a conflict, Justice Tannenbaum, I agree with what his recitation is. The first, the second, the third, and the fifth DCA, all of them have one single element or factor that's really common, and it's that the property owner has some ability to be aware. It was a question of fact that if you walk around the property in Dudowicz or Parker or Deering, there was some sort of open and obvious, or I don't really like to use that, but visibly apparent thing that would have given the property owner notice. Here, there's a huge difference. We're talking about, based on their expert's testimony, the difference in grade, and I'm just summarizing, it's 2.67%, but he testified that the code requires 11 degrees, and this was something like 8 2/3 or something. And so the variation was 2.37%, which is just not something that if you're walking around, you can visibly see.
2.37 degrees, not 2.37%.
Yes, thank you very much. Yes, you're correct.
So you want our new rule of law to be that de minimis code violations are okay?
I think to hold otherwise has a chilling effect on all of the property ownership in our state. It would give pause to every single property owner, because the fear would be that if there is a technical, even the slightest technical defect as it relates to the property code, whether they were aware or not of the code or whether or not they were aware of the breach, it would have the effect of having negligence per se against every single property owner in the state. And I think it would do a great disjustice to our real estate market.
Okay, does anybody have any questions? Okay, thank you very much. You can have 30 seconds to finish up.
Thank you kindly. The trial court erred by denying the directed verdict because it allowed the jury to speculate the element of notice. A directed verdict is mandatory when a plaintiff fails to produce evidence on each and every essential element of their claim. A prima facie showing of negligence or a prima facie showing of a breach of duty does not satisfy the requirement of constructive or actual notice or causation. By affirming the 4th DCA, the Supreme Court will uphold the long-standing requirement that plaintiffs must prove a property owner actually knew or should have known of a hazard, ensuring that Florida businesses are not held strictly liable for latent technical construction deviations that even city inspectors missed repeatedly. Establishing strict liability or otherwise granting the request of Ms. Trezzeri here would have a negative ripple effect on all of Florida markets, real estate markets, and would have a chilling effect, making property ownership in the state abundantly unattractive. And for these reasons, we request that the Supreme Court affirm the opinion of the 4th DCA. Thank you very much for your time today.
I'll start off by having the opportunity to answer Justice Sasso's question as well. I disagree with the answer. I think this case was based, the crux of this case was they found there was not negligent maintenance. I've already pointed out the structure of the holding. It said or not and. The reason we're getting...
Well, what would your client have had to prove? I mean, what needs to be shown for negligent maintenance here? Or what should they have known, or what should the owner have known to implicate the negligent maintenance here?
So to answer that question, and it was referred to as a de minimis difference, there was not a handrail there. So this difference was over double what was allowed, not only by the Florida Building Code, but also by ADA standards. So,
well, there's no dispute that it's a violation of the building code. Mm-hmm. My question is okay, how is the property owner here supposed to have known? I mean, it can't just be like maintaining the ramp by, he didn't pave it the right way and then someone slipped. They didn't use the right asphalt or whatever. This is, hey, your ramp has been out of code for, what, 20 years, 15 years, whenever they changed the building code. And you didn't tear it down at any point and rebuild it. And you also happen to not have known that it was out of compliance. So in terms of maintenance, what were they supposed to know, I guess, or what was he supposed to know, if anything?
So in addition to the expert testimony,
which went to the building code, which was, was a violation of the building code.
He was, Eckert owned and worked at that building. So when they are saying that how would he know, he's working there as well. He's walking that slope as well. Not 4 years, since 1999. That, in addition to the building code, should be that extra evidence.
So walking it every day, he should have known that it was 2.67 degrees off from where it should have been.
Over 5 degrees, but yes.
So is the constructive knowledge, the notice thing though, is what you knew or should have known, that's a factual question?
Known or should have known. I think it's a factual question because you go back to the Justice Lewis's concurrence where they are separating whether it's a transitory foreign substance or not. The
so
fact
could
that
the jury, so as far as what is there to do here? I mean, so could the, could the jury decide, look, this thing, we have eyes, we can see it's not super sloped. We know that this person was, communicating with inspectors. He was trying to, kind of do the right thing, et cetera, et cetera. Could they just kind of weigh that against against sort of the constructive knowledge that you have of the code and say this person acted reasonably? I guess part of what I'm getting at is how much of this is just sort of a fact issue versus us kind of making a pronouncement as a matter of law that under these circumstances, one of these elements can't be met.
Yeah, I think the jury did take those facts under consideration. Also, at trial, they showed a video of the ramp, and they were able to bring in a video of somebody walking the ramp as well. So obviously we didn't go to the site, but they got to appreciate that from the video. And they took all these factors into consideration. They could have found 0% liability or 100% liability, but because they heard from both sides and heard correctly, they found it was a 70-30 split in favor of the plaintiff.
All right, do you want to finish up?
Once again, it was an honor to be in front of you guys. We pray that the Supreme Court today reverses the 4th DCA's decision, because that is in direct conflict with established law in the state of Florida, including the 4019 jury instruction that was given in this case. We're giving a jury instruction and then later on saying that that's not the standard. Thanks again.
Thank you very much. You're excused. No, you're done.
I'm done, right?
Yeah. Okay. I just said you're excused.
Thank you.
Thank you. All right, our next case is Paul versus State of Florida, number 2025-0478. Whenever you're ready.
Good morning, Your Honors. Paul O'Neill on behalf of the petitioner, Clark Paul. Gentleman to my left is Attorney John Mills, amicus counsel. I'll be ceding some of my time to him. Your Honors, a very strange thing happened on the way to selecting a jury in this case. It began unremarkably in the customary fashion. We had a panel of 60 jurors. They were seated. We had a corresponding seating chart, so the attorneys knew the order of the jurors. The panel was questioned as a whole. We proceeded to cause challenges, again, unremarkable, the way it's typically done. It was after cause challenges that the strange thing happened. The strange thing that happened was the judge, over the objection of both parties, scrambled the order of the jurors. And he generated a new list. So they were no longer in the order of the list that the attorneys had. And what did he say to the attorneys? He said, I will have the list, you will not. And as a result of that procedure, when an attorney had to decide whether to exercise a peremptory challenge, whether to reject a particular juror, he had to do so, or she had to do so, with no knowledge of who would fill that seat.
So what? So what? From a constitutional standpoint, what if the order was scrambled by birthday or alphabetically? What constitutional basis is there for this degree of knowledge about the members of the venire that you articulate?
There's no constitutional right to peremptory challenges in the first place.
So
there is a constitution.
Help me understand what you hang your hat on for relief, because it seems to me that just as the order in which the jurors entered the room is a randomly generated
order. As it should be.
So is any other randomly thing, like birthday, like alphabetical, like any other sorting mechanism. What's wrong? Don't you have to show me that the judge in this case abused his or her discretion by doing something that rendered the panel unimpartial, right? At the end of the day, the constitutional right your client has, is to an impartial panel, right?
You're right, sir. And Your Honor, what I'm going to hang my hat on are several well-reasoned decisions from this court. What I'm going to hang my hat on are cases from this court and from the Supreme Court of the United States who, while recognizing that peremptory challenges are not a constitutional right, are nevertheless integral to the selection of a fair and impartial jury.
Yeah, so how, and I know the U.S. Supreme Court has said that right after they say that it's not a constitutional right. So what does that mean? I mean, if it's just statutory and there's not a constitutional dimension to it, then why does it matter whether it's integral to getting a fair trial? Because presumably if you didn't have peremptories at all and you don't have a right to them, you still would get a fair trial if, you know, the 4 cause challenges were exercised properly, right?
I don't know that I agree with that, Your Honor, but I would submit that we have a
Well, how could it be any other way? I mean, if there's not a constitutional right to peremptories, which means you could have a fair trial without peremptories, right?
Your Honor, if this court were to conclude that we could be deprived of our peremptory challenges entirely and there would be no infringement, no problem with that, then obviously we lose the case. So our position depends on the fact that we have, if not a constitutional right to peremptories, a statutory and a procedural right.
Well, right. Well, it can't be a procedural right because rules can't establish rights. But let's just stick with the statute for a moment because there is one. You're saying that the legislature repealed the statute tomorrow, that would be an unconstitutional act in some way? Or that you would still be entitled to peremptories?
I think that if the legislature were to repeal that tomorrow, that courts would still have discretion, perhaps even an obligation, to permit peremptory challenges, and that they could do that because procedural rules, as Your Honor knows, are the province of the court and not the legislature. And while the legislature says you get 3 strikes, you get 10 strikes, as Your Honor knows, a trial judge can say, I'm going to give you 2 more strikes than that. I'm going to give you 3 more strikes than that.
Sure. But if there's not a constitutional dimension to it, doesn't it, just to then get back to Justice Currill's questioning, are we not just talking about a statutory interpretation matter here? So if the legislature said you get 10 peremptories, aren't we just talking about, well, what does that mean in the end?
I don't think so, but it's an interesting question. The reason it's interesting is because both the 4th DCA and the state have placed a great emphasis on the silence of the statutes as to the method of exercising peremptory challenges. I find that curious because we would expect those statutes to be silent as to the method. Again, courtroom procedure is typically the province of this court, not the legislature.
Okay, well, you have to root your argument in the law somewhere, right? So the SG in its brief characterizes it as, frames the issue as, it must be because of some common law tradition concerning the use of peremptory strikes. You seem to take issue with that in your reply brief when you say it's not about that, it's an abuse of discretion, and it turns instead on whether the procedure infringes a party's right to exercise peremptory challenges intelligently and effectively.
Correct. Yeah,
and so what is the issue with the SG's characterization? So we have a statute granting peremptory challenges unless there is some, it is a statutory interpretation issue in the sense that unless there's some, technical meaning of peremptory challenges that includes the ability to exercise it only in this way without this random selection thing, that might make sense. That might be the common law tradition that's imported into the statute granting you peremptory challenges. But otherwise, what are you rooting your right to intelligent and effective use of peremptories to in the law?
2-part answer to that question, Your Honor. I do disagree with the SG's characterization or argument that unless we can root this in the common law or in a statute, there's no there. The reason that I disagree with that is because it ignores something very important, which is that procedural rules don't just live in the common law and they don't just live in statutes, they live in the case law. We have lots of procedural rules that trial courts are obliged to comply with that exist solely in the case law. The procedure for conducting a Richardson hearing, if there's a violation, a Ferretta inquiry, a Nelson inquiry.
Yeah, but those are all based in constitutional provisions and implementing those constitutional guarantees. They're not just made up, as just a matter of court policy.
Well, and we can, yeah, you can connect the dots back to the Constitution. I think you can do the same thing here when you get back to the right to a fair and impartial jury.
Yeah, but even though, well, okay, well, let's take you on that for a moment. So the 10th strike that your client exercised had the replacement was Stacy Palak, I believe, and your client or your client's lawyer at the trial court level simply did a sort of this general objection. Well, if I had gotten more peremptories, I would have stricken. There were 3 other jurors, and then he included Stacy as well, without explaining, hey, had I known that Stacy was going to be the, and I apologize for using the first name, it's just easier than pronouncing the last name, had I known that she was going to be the replacement juror, when I was looking at this whole panel, yeah, the one I struck was bad, but she was worse, and if I'd known, I would never have exercised my peremptory on this juror, and like highlight that would be the injury that your client suffered, and without it, like I've now been denied a fair trial. That didn't happen. So just taking your point for a moment, has it been preserved? I mean, where did your client highlight the injury that was suffered in this case?
Your Honor, I would first point out that there was never an argument at any stage in this case that there was a lack of preservation. I think the 4th DCA in its decision in this case acknowledged the repeated objections as well as the denied requests for additional peremptories, as well as the objection to the final jury that was sworn. Typically under existing case law, that would be deemed sufficient to preserve the issue. So I do believe it is my position that there is adequate preservation.
But you're on quicksand already. I mean, it's been pointed out, like there's not a constitutional provision that gets you there. And we're talking about a statute that just says you get peremptories. And you're saying, well, I didn't get to fully and freely exercise those peremptories because I got stuck with Ms. Palak as this juror, and I would never, I guess the argument is I never would have struck her, except that wasn't pointed out in the record. So what is your, to get relief from a court, you have to identify some substantive harm that your client suffered. So was it the lack of a fair trial in this instance? Was it a violation of the statutory right? What is it?
It was the fact that defense counsel at the trial level was unable to exercise his peremptory strikes intelligently and effectively. This court in Tedder has explicitly said that you have a right to do that. There's other cases that echo that.
But did he not know?
Of course, our argument depends on that. If that's not true, if you don't have a right to exercise your strikes intelligently and effectively, then we lose. I
guess it depends on what you mean by intelligently. I mean, in what way was the strike here not exercised intelligently? It may not have been exercised in a way that ultimately inured to your client's benefit, but that's different from having, when I understand an effective and intelligent use of the right, it doesn't mean that the right will yield the result that I want. It means that I'm aware, at the very least, of the risks involved, and I'm aware of the sort of circumstances under which I'm exercising the right. I mean, it seems to me like the rule you're advocating for is not, an intelligent and effective use. It's a use that makes me happy with my peremptories.
I do want to be made happy with my peremptories, Your Honor, but I have 2 responses to that. One is a very simple analogy, and 2 is rooted in the case law. And the simple analogy is this: if I go out to a restaurant and I'm asked whether I want to have the chicken parmesan for dinner, for me to make an intelligent and effective decision, I need to know what my options are. I need to see the menu. If the waitress says to me, you can have the chicken parmesan or you can have the mystery dish, I'm not making an intelligent or effective decision.
With that analogy. This is not a restaurant, as I say to my children all the time.
And then the other thing I think that supports my position is Turkhurst and Tedder, and I think it's very clear when we read those decisions.
Isn't that kind of all of your position? We kind of, you're really relying on the fact that binding precedent requires this.
Yes, ma'am.
I mean, that's kind of your whole argument. So, because you haven't rooted it to anything other than precedent.
That is the question posed by the 4th DCA. Is this was this procedure permissible under Terkhurst? And Terkhurst, I don't think, is ambiguous or equivocal. Terkhurst, I think, makes it clear that absent exceptional circumstances, parties should be afforded comparative choice when they're exercising their strikes. So I do think that this procedure can't be reconciled with Terkhurst.
Well, except wasn't the problem in Terkhurst that the statute guaranteed a certain number of peremptories, and either one side or the other lost one of those because they both chose the same juror to strike?
I actually...
And that happened because they had to do it all in advance blindly without knowing who was going to be striking what and who was going to be in the box. And isn't the focus who's in the box at the time, not who's in the panel? I mean, sorry, in the veneer.
Your Honor, I absolutely recognize that the procedure that was being scrutinized in Terkhurst was different than the procedure here, but I think that the principles that were articulated in Terkhurst and that led to the conclusion there apply equally here. I also, and maybe this is just an intellectual weakness on my part, I don't understand. If, as the state respectfully contends, that peremptories are nothing but a mere kind of privilege to strike a fixed number of jurors, then frankly, I don't see what the problem was in Terkhurst. Each party got to identify 3 jurors that they wanted to reject.
Well, the problem would have been that they didn't get their full amount, so they were given 10, and because of the way that they had the group striking, that they would have had an extra one had they not struck the same. So I saw Terkhurst as saying there's essentially a procedural rule giving you 10 strikes each. You didn't get 10 because of this method.
Right.
So it wasn't this intelligent effective. It was getting use. There was error in the sense that the rule wasn't followed because they didn't get 10.
Your interpretation of Terkhurst is certainly more important than mine.
We're here to talk about it. So.
Going with it, Your Honor.
Sorry, I don't mean to interrupt you. You're welcome to keep going, but you're reading into your colleagues' time.
Yes, sir. Okay. I want to make 2 points very quickly, and you can carve it off of my rebuttal time. Terkhurst, in finding a fault with this risk of overlapping strikes, what did they say? They said the only fair scheme is to allow the parties to view the full panel. The second infirmity they recognized was that the excess jurors meant that the parties would not know who would serve if excused. I would respectfully submit it follows from that intentionally blinding the parties to the order of the jurors does not comport with those principles that were articulated in Terkhurst.
I don't know if that's working. Good morning, and may it please the court. I'm John Mills, and it is my tremendous honor to have the opportunity to appear before the court on behalf of the plaintiff and defense civil trial bar. I represent today and am presenting the argument on behalf of FLABOTA, the Florida chapters of the American Board of Trial Advocates, which is equally composed of plaintiffs and defense lawyers, as well as trial judges. The Florida Defense Lawyers Association, which represents the civil defense bar, and the Florida Justice Association, of which I am a member in the amicus chair, which represents the plaintiff's trial bar. But I would say that I'm not just speaking on behalf of every civil trial lawyer who picks a jury in this case. I'm also speaking on behalf of the criminal lawyers. The criminal defense lawyers filed an amicus brief supporting the same position. The prosecutors did not, but the prosecutor, the line prosecutor in this case, objected to this, and every prosecutor I've ever met would object to this. Anybody who picks a jury. The people who want the random, the Attorney General's office, don't pick juries and don't get to appeal the erroneous denial of a cause challenge or anything else that happens in jury selection because of the double jeopardy clause.
Presumably you're not including federal practitioners who don't get to do...
I am not speaking on behalf, if they want to come into Florida's courts, we have a different system. Our Constitution is different, our rules are different, and voir dire is very different.
But on this point, I guess what I'm saying is when you say you've never met a juror, a lawyer, I would question whether you're hanging out in the right circles then, because anyone who picks a jury in federal court will tell you that there are plenty of constitutionally sufficient protocols that, you know, do not include the degree of biographical information that you are accustomed to getting with respect to jurors.
They are used to it. I would say they don't like it, but they've gotten used to it, and if they could choose, they would pick this.
I'm not so sure.
And the reason for all of this.
Well, to the SG's point that this isn't a rules case, and I get that I get your point on the consensus of what the practitioners prefer, but can you answer the question on framing the issue?
Yes.
Where is this? Is it truly just are we trying to figure out if binding precedent requires it in this case, or can we root it to some legal concept?
Yes, I think that you have two different roles that are called into play here. You could act under either of them. The first is your appellate capacity. You have jurisdiction now to review this as an appellate court, and the question is, was this an abuse of discretion? The answer is it was an abuse of discretion because this was not a reasonable thing to do. And I'm going to give you all the reasons in a second why it's not reasonable. But if you disagree and you say, hey, reasonable minds could differ here. Some judges do it this way, a few do it this way, most do it the way you're saying, Mr. Mills, but let's have some experimentation. You know, that's in the discretion. Well, then the petitioner loses this case. But I think that then implicates your next role. And the answer brief from the state makes this point, and this court has done exactly what I'm suggesting when it changed the summary judgment standard and when it made punitive damage rulings appealable. And that is, a case can show the need for your Article 5, Section 2A rulemaking powers, both over the bar and over the procedures in court. And you can give procedural rights. They're not absolute. Right. The rules say...
So I don't mean to interrupt you, but I think in the interest of time, since you're so short, instead of giving us like a preemptive argument for a rule change case, it sounds like you might have some arguments on why there was an abuse of discretion.
Absolutely. First off, it was an abuse of discretion because the most important issue here was completely ignored by the trial judge, by the 4th DCA. Also, respectfully, by Judge Shepard in the form order on which this was based out of Palm Beach County. And we've now traced it back. My friend here in the answer brief cited the Weish order from Judge De La O in Miami. That's the origin of this. It started about 10 years ago. And there's a small group of judges who are doing this. And they explain the Weish order's probably got the most reasoning in it. And while it's against us, I think it's worth reading. And in that case, this rule came up because it was a case where the criminal defendant said, I want to know the race of who's going to come on next because I want to make sure I can manipulate the racial composition of the jury. He actually said that out loud. That was the argument. Specifically, I want to know if the next person is black or not because I want to have a black person on the jury. That's not permissible. You can make your peremptories for just about any reason except for race or gender, protected classes. So you had a lawyer, amazingly, brazenly, saying he had a right to racially manipulate. Well, that would be a good reason to come up with something new to prevent, because you can't do that. But they didn't focus on, none of them acknowledged this, and that is the point of peremptories is not whim. It's not for lawyers to get to look smart and stuff. It is because jurors conceal bias today. That didn't used to be a concern. We used to have bystanders, the busybodies who would come to watch the court. If you ran out of jurors, you could just pick from them. We don't do that anymore. Maybe in some rural counties they have to. But we don't do that because we have lawfare now. We have social justice warriors on whatever side of an issue that want to get on a jury. They want to get through voir dire. They got a message to send. That tobacco company, that plaintiff suing a tobacco company, law enforcement who searched somebody's home, somebody who protested against law enforcement, all these things that we have, we are worried, all of our clients.
That sounds like an argument in favor of robust voir dire, which is available in state court, but not so much in federal court.
It is, but it is also an argument that you should be able to know who comes next, because what we do is we rank people. Everyone has their own thing. Let's say it's a 1 to 10 rank, with 10 being the devil. That guy's going to kill me, and I tried a cause challenge, and the judge disagreed. So that's the one I'm worried about, and he's out there. Meanwhile, I've got this juror who's a 6 or a 7. She looked at me funny. She didn't seem to listen when I was talking or rolled her eyes. And man, all my instincts say this is going to be a bad juror. So now I've got jurors, that juror there is a 6 or 7. Do I want to strike her? I should know if by getting rid of this one person who appears to be dangerous but I don't really know, that's going to bring on the devil that's going to kill my case, then that's not, I don't know if intelligent is the right decision, but it's not an informed decision.
But
and we have a right to make informed decisions.
And I've picked jurors, and I've been in this position where I have one and the state has 2 strikes left, and we both know who I don't want and who they want. And so I strike the one, and they use 2 strikes, and that person's back on anyway. But I don't know, but maybe I don't know if they're really going to go through with it. So I'm still exercising a peremptory with an unknown in the end.
You are, and we've been
Which I think is what Justice Curry was pointing out in the first place.
You're exactly right. That's how we do it. We've been doing it for 40 years. But now we're adding something else in. Yes, there are already unknowns, but now we're going to intentionally add an unknown, and we're going to make it into a game show where we're going to have popcorn bingo balls or do something to make it a game.
As a matter of law, it's abuse of discretion when this random jury selection is used because there's a right to do so intelligently.
I think that you should,
precedent or based on, common law tradition.
Based on Canacaris.
Based on what? Sorry.
Canacaris, which is the case that says what the abuse of discretion standard is.
Again, yes, and that's just no reasonable. So why would no reasonable judge do this?
First, because it prevents the purpose of peremptory challenges, which is to get at concealed bias that you can't prove but you know is there. Second,
is that what the legislature understood it to be in 1939, when they
the legislature doesn't, respectfully, you are going to disagree with me on this. The legislature does not have a say. This court has a say on how jury selection is to be conducted. Okay, that's a rule that's procedural. And you can say it's up to each trial judge to do it the way they want. We give them great flexibility. Or you can say you can do it any way you want, but you can't do it this. You have to allow back strikes. That's what you did in Tedder. You can't require simultaneous. That's what you did in Turkotst. Neither of those directly on point here, but the approach is the same. You use the abuse of discretion standard to say, hey, at least absent something that Judge De La O had, somebody brazenly saying, yeah, I want to racially
doesn't that show, though, that so this is essentially a policy question for each judge. So
it's a procedural policy question.
It's a procedural policy question. So if a judge has to go into a jury trial picking a procedural policy, why is it not reasonable for a judge to say this happened in De La O's case? Right. Can't be the only case it happened in. Right. If I'm picking good policy for my courtroom, I'm going to go with random selection.
So I'm going to give you 8 reasons. There's a whole bunch of reasons. There's no reason why it's reasonable.
1 minute to get through your 8 reasons, because otherwise we could be here all day talking about
this. I would love if you would give me some more time, but if you want, it eliminates concealing bias. It presumes the stated justification in all of these is that lawyers are going to engage in racial manipulation. You should not presume members of this bar are going to do that. We don't do that. We've already changed our system on DEI and what can we do in CLE and stuff out of recognition that it is improper to presuppose that this is an issue. Moreover, even if it is an issue, and sometimes it is, criminal cases it seems to be more than in civil cases, but maybe civil cases you have parties of different races or whatever. We already have well-worn mechanisms to prevent that. We know how to do that. We ferret that out. That's the way to deal with it, not a broad rule in all cases where that was not an issue in this case. That was not an issue in Sykes.
Okay,
that was not an issue in most cases.
You got 30 more seconds.
Thank you. Whatever benefit it has, they say it prevents corruption. You know the jurors ahead of time, and you could bribe the first few. Well, A, lawyers don't do that, and you lose your ticket if you do that. And B, randomizing it at the start of voir dire fixes that. You don't know coming in, it's randomized when you show up, but that's the list. It requires more time, not less. You're wanting us to speed up trials. If you want to preserve this challenge or a cause challenge, you're going to have to question everybody there and make a full record to show Judge Tannenbaum, just as you said, that absent this, I would have picked somebody else. Or you want to preserve an erroneous cause challenge, you got to fire your Russian roulette. You got to empty the chamber. You got to use all your peremptories, taking a risk you're bringing on the devil to preserve an error. That should not matter. It doesn't matter that it's neutral. It affects either side both ways. True. But what it does is it means each side has an unnecessarily less chance of having a fair jury. And we should have procedures that promote a fair jury.
Okay,
and
that's a perfect ending. Thank you very much.
Thank you very much.
Mr. Chief Justice, and may it please the court, the origins of this method were not 10 years ago in an order called Weish. The origins were somewhere beyond 1665. I mean, this jury selection method is supported by literally 400 years, maybe more, of Anglo-American history and tradition, and we think by definition it cannot be an abuse of discretion. So I'd like to start with what I think methodologically the court should be doing in cases like this. An abuse of discretion could come from a couple of places. It could come because the trial court violated some principle of law espoused in one of your precedents, or it could come from the text as informed by history of some governing provision of law, whether that's a statute or a rule. They don't have any of that here. With respect to the precedents, the closest they have is ter Kirst, which is, I think, quite obviously dicta, because the court resolved that dispute on the basis of preservation. And the dicta that is out there doesn't speak precisely to this question, but I hardly think that it can be believed, because if you take it seriously, ter Kirst was saying jury box methods writ large are inappropriate, whether they're randomized or sequential. You must use a struck jury method. So the precedent doesn't really help them. And then on text and tradition, what we've shown is that the text doesn't convey the right that they claim, and the history is actually quite to the contrary. And we know that because Florida's early territorial laws through the 1800s used talesmen, which was a randomized selection process. When strikes were exercised, it was up to the sheriff to pick a bystander. And they also used a process of selecting the next replacement juror's name out of a box or a glass. And so when you think about what a peremptory challenge is, you can look and inform your judgment by considering that history. And for those 400 years, no one thought that it was a problem that the next replacement juror was randomized. That just wasn't part of the right inherent in the idea of a peremptory challenge.
So is it your position that the term peremptory as used in the statute, which dates back to the 1930s, if not earlier, incorporates that history and tradition, like that the term peremptory, the concept of peremptory, is limited to just striking someone that's in the box and nothing more to it than that?
No, so I think that when you ask what a peremptory challenge is, you ask about the original public meaning as used in that statute. But I don't think that the history tells us that judges have to use any particular method, because another component of the history is the enormous discretion that judges had to select from a permissible range of options. Our point in talking about the history is simply that history has shown that there are some tried and true, historically tested methods that fall within a safe harbor of options for a trial judge to select from. And so long as the judge selects one of those options and is not innovating in some brand new way that may pose some problems and conflict with historical principles, then by definition you cannot have an abuse of discretion.
Even that would be tough under an abuse of discretion standard. Since you have so much time, can you just tell us for future reference, when you have all of this, these united, it's rare that you see this configuration of people all coming in. It reminds me of the reaction to our initial proposal on changing the civil case management stuff, where we managed to unite all the lawyers in Florida on one view. Prospectively, not in this case. I mean, what would your thoughts be on the wisdom of having a more uniformity and something that was more consistent with what they're saying would make better sense?
So we don't have a firm position on whether there should be a uniform rule. We would take a careful look at that if the court were to propose that, or if that were to come out of the civil or criminal court rules committees. We'd look at all the policy, we'd talk to folks, we'd talk to trial prosecutors and civil litigators in our office, and we'd put forward some informed submission for the court. I mean, what I can say for now is that there are reasonable reasons that a judge would use this method. We've identified them in the brief. Some judges are worried about racial discrimination. I'm sure others are just looking and saying this is a historically tested method where I can't go wrong. I'm familiar with how it works. But if you do go down the road of doing rulemaking, I think an important voice that you haven't heard from today and in the briefing would be trial judges, maybe the most important constituency. This trial judge did allude in the voir dire transcripts to the idea that lots of judges do this, lots of judges like it, and indeed litigants like it for various reasons. And so I think you would want to hear from judges who are on the front lines. They're doing these things for a reason, and you want to know what those reasons are.
Can I ask about the holding and Terkhurst and I think your position is that the holding was preservation.
Right.
And so why is it not that if the court's presented with a certified question and then the court says the procedure used by the trial court therefore denied one of the parties the right to exercise its peremptories, why is that not part of the holding of the case? I think there's a stronger argument that this, follow up, and we think that they should know who comes next as dicta. But why are we looking only at that preservation as holding and not kind of the secondary holding or alternative holding, I guess, that they were denied the right to exercise one of their peremptories?
So Justice Sasso, the existence of the certified question was what gave the court discretionary jurisdiction. Mm-hmm. So the court can comment on that, but I don't think the fact that it's a certified question case sort of obliterates ordinary principles of appellate practice and opinion writing, which is that if the statement in the opinion was not necessary to the outcome of the case, then it's dicta. And it wasn't necessary to the outcome of the case because this court in Terkhurst ultimately upheld the judgment, not the reasoning, but the judgment. And I think that's what matters. But look, if you thought that was a holding, then trial judges have a big problem in this state because most of them are not doing the structuring method, which Terkhurst says in the second piece of dicta that trial judges should be doing. So the structuring method that the court was describing there is that once you do cause challenges, you whittle down the panel so the biased jurors are gone. Terkhurst says then remove everyone else who is not necessary to comprise the, say, 12 jurors on the panel plus peremptory strikes. Okay, so they're actually not complaining in this case that the judge didn't use the struck jury method. They were fine with the jury box method. They just want a sequential jury box method where they know who comes next. And most judges in this state are using a jury box method. So I think the dicta almost cannot be believed. And for 40 years, judges have not thought that they were bound by that.
Right. Well, and plus, and to curse the court, when it's referencing knowing who's on the panel, or it seems to me it's referencing who's in the box, not being able to see everyone and know how all that's going to go in order. Do you agree or disagree on that?
Yeah, I think that's right. I think they're hanging their hat on the language about using the struck jury method.
Right. Well, and I think in just reading it a little bit more broadly as to what the parties need to know in advance. And it seems to me that based on the history and tradition, or the original public meaning of the word peremptory when the legislature originally enacted it, they just had in mind that, okay, you're going to have, just as it had been done historically, you have 6 or 12 in the box, and you see them, and then you know who in that 12 or 6 or 12 that you're striking at that moment.
Right.
As opposed to doing it blindly without knowing who's in the box and who's going to be serving on your jury. Is that...
Yeah, I think
what
that's
it boils down to.
Yeah, that's what's going on in this court's Tedder
But
decision as well.
you don't think that it would be analytically what I thought I heard you saying though was that the question of sort of the abuse of discretion, whether it's an abuse of discretion, is not really answered by looking at what the original public meaning of the word peremptory might have been. I mean, I understood your argument to be, given sort of how long this has been around, and given the reasonable kind of policy things that we've heard as to why you would do this, that it just can't be an abuse of discretion. It may be a bad idea, it may be something that, you know, half of us think is good or bad or whatever, but it's not an abuse of discretion.
Yeah, I think at minimum that. Okay. So we definitely win on the basis of that. But if you're looking more universally, more globally about how do I instruct appellate judges to do abuse of discretion review going forward, which I think might be an important component of this case, then we think the better way to do that is to say, for discretionary calls like this, where the statute or the rule doesn't specify a procedure and leaves it to the judge's discretion, that discretion will be abused only if the judge is contravening some established principle of law that comes from text or text as interpreted.
No, I mean, that wouldn't be right. I mean, judges, if you did something that was kind of arbitrary, I mean, I don't know. We don't need to get into that. But well, I mean, that might be a due process problem. It's kind of black letter law that an error of law is an abuse of discretion, and then you also can abuse your discretion by just doing something, you know, arbitrary. So it just seems like you're sort of trying to maybe kind of meld the two things together. But I mean,
Look, we don't have to get into that. This is a pretty straightforward case, I think, on abuse of discretion.
So I guess the point, though, is that do you see this as a quote-unquote statutory interpretation case?
That is how we have briefed the case, and that is how we view it, that there is no fixed principle of law from this statute looking at the explicit text or connotations about peremptory challenges that you might draw from the old soil of the common law. That's how we see the case. Yes.
And presumably, so there's not a constitutional right to a peremptory,
right?
Which means the only other place we can look is statute for a right, and so they have both sides have a right to 10 peremptories in a murder case, or a capital case, and presumably a court could not subtract from that right with a procedure, right?
Correct.
Which means that the harm, which they have to show to get any sort of relief, the harm would have to flow from some procedure that the judge exercised or implemented that subtracted from that right, correct?
As originally understood. I think that's the answer. But even if you were to entertain a more free-form, balancing, reasonableness approach to abuse of discretion, you know, for the reasons in our brief and discussed today, I think this trial judge was well within the bounds because there are good reasons for what the trial judge did. So I'll just end by saying we don't think that you should create, you know, we have an evolving standard of decency standard for the Eighth Amendment. We don't think you need one for jury selection. You don't need evolving standards of jury selection, which is really what the other side's position amounts to. So
at least ones that aren't put into a rule.
If you wanted to change the rule, that would be a very different story. That would be but it wouldn't be a basis for retroactively invalidating these homicide convictions.
What about the idea, though, that if I'm sitting there and I'm trying to exercise a peremptory, and it's like Mr. Mills was observing, you have a 10, which I don't understand how a 10 wouldn't have been stricken for cause, and it sounds like error that might be reversed on appeal. But let's just assume it's an 8 and a 6. You know, and this is all this is gut. I mean, the lawyers are sitting there in real time with big charts and lots of writing on them. They're just going with their gut in the end, like, how do I feel about this person?
Yes.
How does a person, in this court and the U.S. Supreme Court has mentioned sort of the getting rid of the most concern. I mean, I'm paraphrasing, but the most concerning of the remaining jurors that haven't been stricken for cause. How does a lawyer make that assessment about most comparatively without knowing who the next one might be?
Well, that's why we cite the history, because, you know, for 4 centuries, the understanding of the peremptory challenge was that you looked at the particular juror you were faced with right then and there, and you assessed that juror. You didn't do the comparative assessment. I mean, that's part of the flaw in the argument. They say, well, to intelligently and effectively use our peremptories, I have to be making comparative judgments about, you know, somebody coming 6 down the line. And that was just never how peremptories were used. That's just a fallacy that is somehow baked into the right of using peremptories. But as you were saying, Justice Tannenbaum, there is always going to be some risk inherent in any jury selection method, because you don't know what your adversary, after you exhaust, is going to do. And maybe your adversary does have enough strikes to get to that, you know, the hellish juror that we heard about earlier. That, you know, that's sort of life in litigation and tough cookies. Thank you.
All right, thank you very much. And you can have 1 minute.
Lightning quick, 2 points I want to respond to: discretion and history. The emphasis on discretion is misplaced here. What does the SG say in its answer brief? It says the hallmark of jury selection is the wide discretion enjoyed by the trial judge. I would respectfully submit that's incorrect. The hallmark of jury selection is picking a fair and impartial jury. Kanakaris says judges are not free to innovate at their pleasure. This was an innovation. Fourth DCA says, he says, we've never seen this precise method before. They said that in their decision. As a result of this innovation, our client, who was on trial for his life, was disadvantaged in a way that 95% of other criminal defendants weren't. 95% of other criminal defendants or more had the benefit of comparative choice when exercising their strikes. He didn't. As to the historical cases, 200 years old, 300 years old, why are they bad guideposts? Well, the historical tradition tolerated many things in jury selection that would never be tolerated today. Racial and gender exclusion, tolerated juries who knew the parties, who had personal knowledge of the disputes. We have cases and cited by the SG where the sheriff was allowed to go out and personally select jurors to fill vacancies.
15 seconds to finish up.
Yes, sir, Your Honor. So we are not asking you for a new rule. We're asking you to apply the rules that were articulated in Terrorist and Tedder. Privileged to be here. Thank you for your time.
Thank you very much. We're adjourned.